First case to come before the court is State versus Hendon, and we'll just be hearing from one side this morning, so you will have 15 minutes to present your argument to the court.
Thank you, Your Honor.
You may proceed.
Good morning, Your Honors. May it please the court. My name is Elizabeth Well, and I represent the appellant Rhonda Blankenship. Ms. Blankenship was the victim of an attempted murder in the case below, in a crime in which appellee Eric Hendon, with help from his brother Michael Hendon, broke into her home, executed her boyfriend and his 2 children, stabbed Ms. Blankenship in the face, shot Ms. Blankenship in the eye. Ms. Blankenship was able to play dead until the appellee left. She was able to pull the knife from her face and call 911, which was how she survived. Ms. Blankenship contacted the Ohio Crime Victim Justice Center when Eric Hendon's trial was going on, because she learned that Mr. Hendon was going to be seeking some of her privileged and confidential medical and counseling records. And the defense sought these records in 2 ways. Both of these ways culminated in a hearing on December 17, 2015. First, the defense had filed motions ZZZ, quadruple A, and quadruple B, in which the defense sought not only Ms. Blankenship's medical and counseling records since the night of the attempted murder, but also access to her Facebook and email, in that they sought her Facebook usernames and passwords and email usernames and passwords. The defense also sought access to Ms. Blankenship's cell phones, tablets, and computers that she had used to view, transmit, or receive any information about the case. Those motions were filed pursuant to Criminal Rule 16, which regulates discovery between the prosecution and the defense. The December 17th hearing was convened to hear that motion and the state's and my office's memos in opposition to that motion.
So at that point, the state was objecting.
Yes, Your Honor. The state objected on the same grounds that we objected, which was that the proper procedure was Criminal Rule 17C subpoenas to Ms. Blankenship and her medical providers, and not Criminal Rule 16 motion to compel. The prosecutor stated at the time and held throughout the entire criminal case, and so was our position, that the prosecutor did not have access and did not have possession of any of the materials or information sought in defense motions ZZZ, quadruple A, and quadruple B. That day, we were allowed to present oral argument to the court, as did the parties, and the court did not rule that day on the defense motions. At the same time, there was an individual in the back of the courtroom who came forward at the end of the hearing and presented herself as Akron's keeper of records. She had brought, pursuant to a defense subpoena, medical records of my client, Ms. Blankenship. My client was not made aware of this subpoena. As Your Honors may know, the docket was sealed, so there was no way to know that the subpoena had been sent out, and the defense had been indicating that they only needed to pursue these matters pursuant to Criminal Rule 16, and that Criminal Rule 17 was actually improper. The keeper of records came forward and said she would only turn over the records if the court issued an order. The court issued an oral order and took possession of the records, and then the court later memorialized that order in a judgment entry. The court took the records in camera for review, and on December 28, 2015, the court, following the in-camera review, turned over in full Ms. Blankenship's medical records from Akron General, and the court also put forth orders which were based on the defense's proposed orders that stated that I, as Ms. Blankenship's counsel, was to conduct a factual inquiry with my client, a factual investigation, and I was to get information about Ms. Blankenship's medical providers, counseling providers, Facebook username and password, as well as her email usernames and passwords, and I was to turn that information over to the court and a defense expert in violation of attorney-client privilege. I refused to do so, and the court had set a status hearing for January 7th, 2016. As soon as the orders came down, Ms. Blankenship filed an appeal, and that was case number 28067, and the 2 assignments of error were the violation of attorney-client privilege and her constitutional right to privacy in her medical records, and the violation, of physician-patient privilege as well. She also filed simultaneously with the notices of appeal a motion for stay pending appeal in the trial court. On January 7th, when the trial court held the hearing, I was present along with both the state and the defense, and the court indicated that the state and myself and my client had not complied with the court orders at that time, and the court was willing to do whatever necessary to vindicate the authority of the court, including sanctions under Criminal Rule 16, such as excluding Ms. Blankenship, who was the only eyewitness, from testifying at the trial. The state, as well as myself and Ms. Blankenship, became convinced that the trial court was going to do just that, and they filed subpoenas on January 7th and January 8th, seeking the information that the trial court indicated had been, the information that the defense had sought in the motions that had been granted, which were defense triple Z, quadruple A, and quadruple B. Ms. Blankenship immediately filed motions to quash those subpoenas, both the subpoenas that were sent to her and the subpoenas that were sent to medical providers for her medical records. There was a hearing on January 14th, 2016, in which the court indicated that it would not be hearing the motions to quash and conducting an evidentiary hearing, but instead it would take possession of everything that Ms. Blankenship had produced pursuant to the subpoenas under Criminal Rule 16, so that Ms. Blankenship could not object under what was laid out in Criminal Rule 17C to provide for her objection. So essentially, the trial court circumvented the criminal rules, took possession of items pursuant to Rule 16, and denied Ms. Blankenship notice and opportunity to object via a subpoena, a motion to quash the subpoenas. The trial court erred when it used the improper procedure, and the trial court erred when it ordered the privileged and constitutionally protected medical records to be turned over. And finally, the trial court erred when it ordered me to conduct a factual investigation of information from my client and turn that information over to the court and the defense expert in the lower court. As to the procedural background, it's important to note that the entire backdrop of this case is that the trial court used the improper procedure under the criminal rules. Rather than using Criminal Rule 17C, which was designed as the only mechanism by which the state or the defense should be able to get information or materials from a third party, the trial court used Criminal Rule 16 and indicated that the state would be responsible to get the information and materials and turn those things over. Criminal Rule 17C has a particular mechanism in place that's designed to protect third parties and to make it more difficult for the parties of criminal cases to get information from innocent third parties. That mechanism is that a subpoena is filed. The person from whom the information is sought has an opportunity to object to the subpoena pursuant to a motion to quash. Once a motion to quash is filed, the trial court must conduct a hearing in which they look at the factors in the United States Supreme Court's Nixon test, which was adopted in Ohio by the Ohio Supreme Court in a case called In Re Subpoena Ducis Tecum served upon Potts. The Potts test is as follows. The proponent of the subpoena has to prove that the information that they sought is evidentiary and relevant. There is no other way for the proponent of the subpoena to get the information using due diligence. Without the information, the person seeking the information would be prejudiced and trial might be delayed, and that the application in the subpoena is made in good faith and is not a general fishing expedition. Even if the defense had been able to satisfy the Nixon test, once Ms. Blankenship claimed privilege over the medical and counseling records and various other items, the trial court has to conduct an in-camera review before it rules on privilege to determine whether or not any of the material should be turned over. It is our position that the trial court and the defense knew that the defense could not meet the Nixon test because this was in fact a general fishing expedition, and so instead the trial court allowed the defense to proceed under Criminal Rule 16 improperly, which circumvented the criminal rules and stripped Ms. Blankenship of the protections the criminal rules are designed to provide. In addition, the trial court also erred when it turned over Ms. Blankenship's confidential and privileged, constitutionally protected medical records without giving her an opportunity to object. For the first set of medical records, the keeper of records was simply there at a hearing. There was no indication whatsoever that those records would be turned over, and there was no chance whatsoever for Ms. Blankenship through counsel to file a motion to quash. The second set of medical records were turned over after the court issued orders to different providers that Ms. Blankenship had listed pursuant to the subpoenas issued by the state. Ms. Blankenship did file motions to quash for those, and those motions were never heard and were never granted nor denied, just as the motion to stay was never granted nor denied, although it was taken under advisement several times in the trial court. The United States Supreme Court, the Ohio Supreme Court have all held that all citizens have the right to privacy under the United States and Ohio constitutions. The Ohio Supreme Court has also explicitly talked about the right to privacy in medical records, when the Ohio Supreme Court said that it should be for the individual, the patient, to determine how their medical records are disseminated and used. It is not for a court or lawyers or medical personnel to determine what an individual's interests are in their constitutionally protected medical records. In addition, the medical records the court turned over were protected by the physician-patient privilege, which is codified in ORC 23-1702B. That provision expressly states that communications between physicians and patients for the purpose of medical treatment are privileged, the patient is the holder of the privilege, and communications expressly include medical records. So in this case, the trial court circumvented the criminal rules, and also violated Ms. Blankenship's constitutional rights and her statutory privilege. And what makes it all the more egregious is that the defendant did not have a constitutional right to discovery. The United States Supreme Court has been very clear that defendants do not have a constitutional right to discovery. Those are only laid out in the rules, and that defendants also do not have confrontation clause interests in discovery. So the lower court violated Ms. Blankenship's constitutional rights, did not conduct a weighing test because the defense, in fact, had no constitutional rights that would justify the violation. In addition, the trial court issued orders that violate attorney-client privilege when it ordered me to conduct a factual investigation of information from my client and turn that over to the trial court and to the defense expert. In Ohio, the attorney-client privilege is statutory in nature, but it also is common law in nature. The statutory attorney-client privilege is codified at ORC 23-1702A, and it's testimonial in nature, and it prohibits an attorney from testifying as to anything learned in the attorney-client relationship. This court has actually extended that to information sought in the discovery process from an attorney as well. The common law
I'm
privilege...
going to stop you for just a minute because, in all honesty, I think this is all very confusing because we don't have both sides really arguing the case.
Sure.
And it's a little unusual, as you know.
Yes, sir.
I know I've never seen a case like this in my 20 years on the bench. So I'm just going to ask for your patience here in trying to figure out exactly what happened a little bit.
Sure.
So I understand about the balancing test. I understand the law. I'm just trying to figure out procedurally what exactly happened. And I understand that you are indicating that you were not aware of the fact that they had subpoenaed these records. You were in there on a Rule 16. You thought that discovery dispute and arguing against it. And your allegation is that the other side, the defense, knew that they had already subpoenaed those, even though they were arguing against it and so forth.
Yes.
All right. So the court did do an in-camera review, though.
Yes, Your Honor.
Okay. Which is more in line with the Civil Rules 17C than it is 16, criminal rule. The in-camera review, which goes along with your Nixon case and so forth, right?
For the in-camera review in the Nixon case, if the court had complied with 17C, they would have had to conduct the evidentiary hearing prior to the in-camera review.
All right.
So essentially skipped a step.
That may be, but I guess my point is that's kind of like a hybrid. It really wasn't a 16 either.
The court was completely clear in all of the orders that the court was doing this pursuant to Criminal Rule 16. The defense motions were filed pursuant to Criminal Rule 16. The court actually stated that the state had violated the orders because they hadn't complied with Criminal Rule 16 in turning these materials over. So there was no indication whatsoever from the trial court that she was trying to concoct a hybrid between Criminal Rule 16 and Criminal Rule 17.
Okay. All right. So then we go to trial. When did you file your motion to stay with the trial court?
We filed the motion to stay on the same day we filed the notice of appeal, which would have been January 5th of 2016. So it was far in advance of trial.
Okay. So you indicated that the trial court did not rule on that.
Correct.
Okay. And did you file anything with this court?
We did not.
Okay. All right. And you didn't file any mandamus or anything to get the court to rule on it?
Correct, Your Honor. It's my understanding that in order for this court to be able to look at the motion to stay has to be either granted or denied in the lower court. And so the lower court neither granted nor denied the motion to stay, but rather took it under advisement several times and stated that the court would issue a written ruling, but never did so. So in order to be in compliance with the appellate rules, there was really no way to go forward in this court because the motion had not been granted or denied below.
I understand that, it's a difficult position to be in, I'm just wondering, then you didn't, you probably elected not to file any type of original action like a precedent or a mandamus or anything in order to get the court to comply
Correct, Your Honor.
by ruling.
There were several hearings over a period of several months where the court indicated that a ruling on the motion to stay was forthcoming. And so it essentially put us up against interfering with the trial, filing something.
It's a very unusual situation, I understand that. So then you have the trial, the records are released to the defense attorney, to the defense, and they're saying there's no objection, because obviously they're saying it's all moot at this point.
Yes, Your
They're
Honor.
saying that there's no objection at trial.
As far as I know, the state did not use the medical records. I believe the defense may have used them but not introduced them with their expert. There was really no
But they
opportunity.
were released to the expert.
They were released, yes, and we filed, as soon as they were released from the trial court, we filed the notice of appeal. So for each of the releases of records, there was one that occurred on December 28th, and there was one that occurred on February 1st of 2016. We immediately appealed, and of course argued in the trial court that those records should not be used. So I think we noted our objections for the record at every given opportunity. I believe that their argument is a bit disingenuous, and they're not here to defend themselves.
I understand. I don't know if the panel has any other questions. Unfortunately, you're out of time. Quite frankly, I could listen to this and debate it for a lot longer, and I think the other members of the panel could as well. But we have had the lapse of time here for which are allotted this morning. The matter will be taken under advisement. You can rest assured that the court will go through the whole record, pour over this, and make a written decision that will be sent to you and to the other side.
Thank you very much, Your Honor.
Thank you. And it will be released on the court's website and the Supreme Court website as well.
Thank you.
Thank
very
you.
much.